Good morning, Prof. Yan.
Good morning.
All participants, I have your attention. Our class is begin. Good morning, Prof. Yan, and
Good morning
and good afternoon, all participants. Welcome back to the 3-in-1 program with Prof. Yan from Institute of Criminal Law and Criminology, Leiden University. My name is Faizin, Prof, and I'm going to be the moderator today. The topic of 3-in-1 today is about criminal case dismissal and restorative justice. Allow me to speak bahasa, Prof. Jadi teman-teman mahasiswa, topik yang dibawakan Prof. Yan hari ini sangat menarik karena penghentian penyidikan. Jadi criminal case dismissal itu penghentian penyidikan, penghentian penuntutan, ya. Nah, ini dengan cara restoratif justice ini satu hal yang menarik. In criminal procedure law in Indonesia, criminal case dismissal known as penghentian penyidikan. So a lawsuit is closed with no finding or guilt and no conviction for defendant in criminal case by court. Yeah. For information, all participants can ask a question after the presentation by raising your hand and say your question, or you can type your question in chat box. Okay. Moving along to our session, please welcome Prof. Yan Prince. Please, Prof.
Thank you very much. Thank you very much for your kind introduction. I hope you can hear me loud and clearly. Is the sound good?
Yeah.
Yeah. Okay, that's good to hear. I'm giving this lecture from home because my family is ill, so that's why I'm staying home. So the other lectures were from the faculty, but now I'm lecturing from home. That means that I cannot see all of you at the moment, but I can see my slide and I can see a few of you. Welcome again, and it's a great pleasure and a great honor to deliver this lecture for you. It's the fourth lecture in a series of four. Let's see, let's move on. Yeah, here it is. It's the fourth lecture. As you all know, we already discussed an introduction, and we already discussed the role of the prosecutor. Last week we talked about the role of the examining judge, and today we will talk about a criminal case dismissal and restorative justice. And when we talk about criminal case dismissal, we also need our knowledge of the second lecture on the role of the prosecutor. Some slides I will show you today I've also shown you in the second lecture, because an important principle in Dutch criminal justice is the principle of opportunity, principle of discretionary powers, opportuniteit, and that means that the public prosecutor does not have to start prosecution. He can also dismiss the case, and that is very different from the criminal justice system in Indonesia. So I can imagine that criminal case dismissal is a topic which is very interesting for you from a comparative perspective. So we will talk about criminal case dismissal again, but today we will talk about criminal case dismissal in the context of restorative justice, and from the perspective of the position of victims. We haven't talked a lot last lectures about the victim. We we concentrated on the position of the accused, and of course we've talked about the prosecutor and on the courts and the examining judge, but the victim is also a very important player in criminal justice. But as we will see, the position of the victim has been strengthened the last decades a lot. So now in 2022, the position of the victim is much stronger in Dutch criminal justice than it used to be. And that's why there's also more attention for restorative justice. And if I've understood correctly, restorative justice is also an important topic in Indonesia. So I'm curious to hear from you what the discussions are on restorative justice in Indonesia. So that will be the three topics for today. I think I will talk for, well, maybe 45 minutes, and of course there will be a Q&A afterwards, as the moderator already told you. But if there are questions during my lecture, please feel free to ask them or to send them in the chat. Okay, let's start. The position of the victim. Well, in the introduction a few weeks ago, I've told you that our Code of Criminal Procedure dates from 1926. So it's about 100 years old, and in that code, there wasn't really a position for the victim. We considered the victim until I think the 80s, maybe 90s of last century as an instrument of truth finding. Of course, the victim was important, but especially as a source of information of what happens during the crime. Of course, the victim is an important witness. He was there when the crime was committed. He was the victim of the crime, and of course, the victim can talk from his own knowledge as a witness about the crime. So of course there was a position of the victim, but almost only as a source of information. But we didn't consider the victim as a carrier of procedural rights. We didn't think about the victim as someone who has also interests in the criminal proceedings. We thought, well, the victim is only a source of information, and well, we are the state and we are going to start criminal proceedings, and we are going to do that in the interest of society and in the interest of the victim, but we don't need the victim in criminal proceedings, actually. That was the classic view on the position of the victim. There weren't very much procedural rights. One of few procedural rights that were in place was the right to complain against non-prosecution. You see it on the second bullet. When the prosecutor decided to dismiss a case, well, then the accused, of course, was happy, but the victim was not. And that's why Article 12 of our Code of Criminal Procedure offers the victim the right to complain against non-prosecution. He can complain to the Court of Appeals. And when the Court of Appeals said, well, I agree with your complaint, we are going to order that the prosecutor has to prosecute the accused instead of a dismissal. So there was a right for the victim to complain against non-prosecution, but that was almost the only right the victim had within criminal proceedings, and for the rest, as I said, he was considered as a source of information who could report a crime to the police and who could act as a witness. That was all, actually. But in the 80s, in the 90s of the last century, there was a lot of advocacy for the position of the victim. It was not considered fair anymore to place the victim actually outside criminal proceedings. We fought well for a good, for the interest of the victim, it would be better to involve the victim in criminal proceedings as well. So from the 90s, we've started to create legislation in the Netherlands, but actually also in Europe as a whole, because some of the victim rights are esteemed from a European source, from the regulations of the European Union. But from that on, we created a legal position for the victim in criminal proceedings. And now we have in the Code of Criminal Procedure, in the first book, starting from Article 51A, a whole title in the book on the legal position of the victim, with several rights for the victim, and not only for the victim himself or herself, but also for heirs of the victim. So when the victim has died as a result of the crime, or will die later on in criminal proceedings, then the rights of the victim can also be invoked by the heirs of the victim or the relatives of the victim. Okay, and who is a victim? Well, we all know what a victim is, but there's also a definition in Article 51A, and that states that a victim is everyone who suffered material or immaterial damages due to a crime. So it can be, you can be a victim because you suffered material damages, but also immaterial damages. So it's also about well-being. All right, let's move on, because I will show you the procedural rights which are in place in Article 51A and later on. The first right in Article 51AA of the Code of Criminal Procedure, well, states that there's a right to be treated respectfully. It's an obligation of the police and of the public prosecutor to treat the victim respectfully. Well, that's kind of a broad right, and it's, I would say it's only a matter of politeness to treat someone respectfully, but it means that you have to think about and you have to consider the interests of the victim during the whole criminal proceedings. And it, for instance, it might imply that you think about the place of the victim during trial. Where are you going to, literally, where is the victim going to sit in court? Is he going to sit in court close to the accused, or maybe next to the accused, or right behind the accused? That can be very intimidating for a victim. So that's why we also offer the victim in serious cases the possibility to follow the trial out of another room in the court, and then via a video link he can follow the trial without being next to or in the neighborhood of the accused. So the right to be treated respectfully is a very open right, and it means that you have to think about what will be in the interest of the victim. But there are also more concrete rights. For instance, in 51AB, the right to information. Of course, a victim has the right to be informed about, well, I would say all aspects of criminal proceedings, but I think all aspects, that is too much. But he has to be informed about the information which is important for the victim. Of course, he must know when court hearings will be. He must know what the accusation against the accused will be. He must be informed about the possible release of the accused or the convicted. He must be informed about the verdict, of course. He must be informed about his rights. He must be informed about the possibilities to claim damages. So there is a lot of information that is important for the victim, and police and the prosecutor are obliged to inform the victim about all these rights. And of course, the victim must be informed in a language which he can understand. So there's also a right to translation. There's a right to translation of all kind of documents which are important for the victim, but which are in a language he cannot understand. Then this information will be translated for him, which you can read in Article 51CA. And then in Article 51B, the third bullet, there's also a right for the victim to access to the case file. So he will be placed in a position that he can read those parts of the case file which are important for the victim. But the prosecutor may make a selection, because there will be also information in the case file which is not suited for the victim, is not suited for the victim to read. For instance, personal information on the accused. It can be also medical information on the accused. Well, that is information which will not be provided to the victim only when it is spoken, which when it's relevant for court trial, and then that information will be given during court trials, but then the information will not be given to the victim in the case file. And another right is that the victim may also add relevant information to the case file. When the victim thinks, well, I have also important information on the crime, and I think it is important to add this information to the case file, he may ask the prosecutor to add this information to the case file as well. But it is important to stress, I should have done this maybe at the beginning, the victim is not a party in criminal proceedings, meaning that he has his own right to prosecute the accused. The victim cannot prosecute the accused. There are countries, Western European countries, in which there's a prosecution right for the prosecutor, but also for the victim. That is not the case in the Netherlands. In the Netherlands, prosecution is really a matter for the public prosecutor, and the public prosecutor may or must take into account the interests of the victim. but the victim is not prosecuting himself. But again, he can add relevant information to the case file. Okay, let's see. Then the fourth one, the fifth one I already mentioned, the right to translation, but the fourth one, there's also a right to assistance and for the victim. It can be assistance of a person who is close with, but it can also be legal assistance of a lawyer. So the victim is not alone in criminal proceedings. He may ask for assistance of a lawyer. And that is important because, as we can read in Article 51E, there's also a right to make a victim impact statement. And I do not know if you are familiar with the concept of a victim impact statement, and if there's also a possibility in Indonesia to make a victim impact statement, but it means that the victim during trial may inform the judge, but also the prosecutor and the accused about what the crime did to him, about the consequences of the crime for the victim, about how the victim is feeling. How is it going with the victim? What were the consequences? Is he sleeping well? Is he? Does he have negative consequences financially or mentally or physically? So he can inform what the judge on what the impact of the crime was to the victim. That is something different than a witness statement. Of course, the victim can be heard as a witness also during trial, but then he is talking about the crime itself, what has happened, how was the crime committed. Then he's talking as a witness, and then there can be then he's under oath, etc. And then his statement can be used for evidence. But that is different when we talk about a victim impact statement. The victim impact statement is just for informing the judge how the well-being of the victim is. Is he feeling well? Is he feeling bad? What was the impact of the crime to the victim? Well, we have this right for a victim impact statement since about 15 years, and we have broadened the scope of the victim impact statement during last years. Originally, the victim impact statement could only be on the consequences of the crime and the impact the crime made on the victim. But now, since a few years, the victim may also inform the judge on what he thinks the judge must do with the case. So he can advise the judge, well, you should convict the accused, and I think the accused deserves a certain sentence. I think he deserves 4 years imprisonment, 6 years imprisonment. So the victim can give the judge an advice. I think that's a difficult change in Dutch law, because the judge don't need an advice on how he should judge the case, and the prosecutor will advise the judge as well, and of course the lawyer of the accused will take a position, but now the victim can also take a position on what the judge should decide in the criminal case. So the scope of the victim impact statement has been broadened the last few years. I see there's a question in the chat. Maybe someone can translate it for me. Or maybe it is not a question. That could also be. Oh, it's from the moderator. I see it. If there's not a question, I will move on. So that is the victim impact statement, and I'm curious to hear what you think about that possibility, and if that's possible in Indonesia as well. Another important right for the victim, of course, is in Article 51F, the right to compensation of damages. Of course, the victim can claim, can make a claim for compensation. His position may be affected financially or mentally. So it can be material damages, it can be immaterial damages, and there's a right for the victim to claim compensation to the accused. Well, this right was always in place, you could say, because it's a civil claim. It's a claim of civil law. You can claim damages in civil, in private law, and that right was always in place in tort law, I must say. But the Article 51F states that you could also add this claim to the criminal proceedings. So it will stay a claim of civil law, but the Article 51F facilitates that the civil claim will be combined with criminal proceedings, and then the criminal judge, the trial judge in the criminal case, will decide on a civil claim on compensation as well. So then the victim, it's more easy for the victim. He does not have to start civil proceedings himself. He can just add his civil claim to the criminal proceedings, and then within criminal proceedings there will be decided on the civil claim, and then the government will also help the victim to actually get the amount of money which is ordered by the judge. So it is a possibility for the victim to claim his damages more easily than he could do within civil law. So I think that's an important improvement, and it's used very widely in the Netherlands. Almost in all criminal cases with a concrete victim, there will also be a claim to compensation of damages. And then finally, in 51H, we see restorative justice as a possibility. And it's a broad and very open article, because it states that, as we will see later on, that the police and the prosecutor will inform the victim and the accused on the option of restorative justice. So it's not an obligation, but the only obligation there is that the police and prosecutor will inform the accused and the victim that they could voluntarily involve themselves in a process of restorative justice, and we call that in the Netherlands mediation. It's not Dutch; it's English as well. But I don't think that mediation is used in English very much. Mostly we talk about restorative justice, and what it is we will see later on. So these are all kinds of procedural rights for the victim, and again, the conclusion on the position of the victim in 2022 would be that the position of the victim has been strengthened a lot during the last decades, but still he's not a party to criminal proceedings. He cannot start criminal proceedings by himself. He cannot prosecute the accused. Still, prosecution is a autonomous decision of the prosecutor, but when the accused is prosecuted, the prosecutor must take into account the interests of the victim as much as possible. And the victim can invoke all these rights during criminal proceedings. So there's really an important position for the victim. Okay, well then to criminal case dismissal, because we will need that to understand restorative justice in the Netherlands a bit better. As I've told you in the second lecture, and as I've already mentioned during the start of this class, in the Netherlands, the prosecutor is not obliged to start prosecution. He doesn't have to. He may also choose to dismiss or to divert the case because of reasons of public interest. And that is the principle of discretionary powers, the principle of opportunity. When the police finished the investigation, the case file will be sent to the prosecutor, and then the prosecutor has to decide on prosecution. And of course, when there's not enough evidence, he will dismiss the case. The prosecutor is not obliged to start prosecution when that would be useless because there's not enough evidence. So we call that technical reasons for dismissal. If a trial won't be successful, of course, then the prosecution does not have to start. The prosecutor does not have to start prosecution. That is obvious. But what is less obvious, especially maybe from an Indonesian perspective, is that the prosecutor may also dismiss a case because of reasons of public interest. He may also dismiss a case which would be or could be successful during trial. But there's a heavy caseload for the prosecutor. There are more criminal cases than he can deal with. So that's why he may choose which case he will bring to trial and which cases he will divert or dismiss. Because the prosecutor also have a lot of possibilities to deal with the case himself. He can also give a penal order, which I will show you on the next slide. He can also give a transaction. He can also give a conditional dismissal. So there are a lot of possibilities for the prosecutor to deal with a criminal case, and going to trial, going to prosecute the accused for during a trial is only one of the options for the prosecutor. He has more options, and one or restorative justice is something which can take place during trial, but also can take place during or in the context of a conditional dismissal, as I will show you later on. So it's important, the principle of discretionary powers gives the prosecutor several options, and promoting restorative justice is also one of the options, but of course, the prosecutor will need the the cooperation of the victim and the accused. So the opportunity principle is really at the basis of Dutch criminal proceedings. It's not only an individual decision of the prosecutor. The opportunity principle, the principle of discretionary powers, gives also a legal basis for developing policy guidelines. We have a lot of policy guidelines in the Netherlands for the prosecutor, and every citizen in the Netherlands can read what the possible decision on prosecution will be in his criminal case when he will read the guidelines. And in the guidelines you can read, well, if it's the second or third time you will be arrested for shoplifting, well, of course, then you will go to trial. But in the first time, well, maybe you can get a penal order. So there are a lot of guidelines which give information on how the prosecutor is dealing with his principle of discretionary powers. So here you see the different options, the several options which the prosecutor has after completing the investigation. Going to trial, as I said, is one of the options. Of course, you can also go, well, you can always go to trial. But you can also dismiss a case, and that is what we call a sepo, seponering, which is slightly different from what you call seponering in Indonesia, but it's an unconditional dismissal, and that means you're just dropping the case. You're just say, well, we are not going to do anything with this case anymore. Well, that's not a great response to a crime. So an unconditional dismissal, well, of course it happens, but mostly the prosecutor will choose for another option, to give a certain reaction to a crime. So a better, in most cases, a better reaction is a conditional dismissal. And a conditional dismissal means that the prosecutor will dismiss the case, he will drop the case, but only under certain conditions, conditions which have to be fulfilled by the accused. So he will, there is some noise in the background, maybe you could switch off your microphone if possible. In a conditional dismissal, there will be conditions which have to be fulfilled by the accused. So, for instance, the prosecutor will say to the accused, "Well, I'm willing to dismiss the case, but I will do that, let's say, in about a year. But I will only dismiss it when you show that you don't commit crimes anymore." So then the accused has to show that he will stop committing crimes. And if he actually is doing that, then the prosecutor will say after a year, well, the crime which we have arrested you earlier for, well, we will dismiss this. But then it will be a dismissal under certain conditions regarding the behavior of the accused. So that is an important and useful reaction to certain crimes. Of course, only when it concerns minor crimes. Of course, you will not use unconditional dismissal in serious crimes. In serious crimes, of course, you will go to trial. But in minor cases, the conditional dismissal with conditions to the behavior of the accused can be an interesting reaction of the prosecutor. And as we will see later on, this is also the legal this offers also a legal possibility for restorative justice, because then you can say, well, I am willing to issue a conditional dismissal, but first you have to start restorative justice. First, we, as a prosecutor, I would like to see whether the victim and the accused can make an agreement in the context of restorative justice. And when there is an agreement on restorative justice, then the prosecutor may dismiss the case under the condition that the accused will fulfill the agreement which he has entered with the accused, with the victim. So that's the conditional dismissal. We also had the transactie, and the transactie, the diversion or the extrajudicial settlement, that is also a kind of conditional dismissal. But then the accused must pay a fine to divert a case, in order to divert a case. Then the prosecutor will say, well, I'm willing to dismiss the case, but only if you pay a certain fine. And if you pay that fine, well, okay, then I will drop the case. That is kind of an agreement between the accused and the prosecutor. So that's also an option. But that option is still used in the Netherlands, but not that much anymore, because now, since about 10-15 years, we have the penal order. And that is also about extrajudicial settlement of criminal cases. So settle the case without the involvement of a judge. But when the prosecutor is issuing a penal order, then it's not an agreement between the accused and the prosecutor. Then the prosecutor will just state, well, I think you're guilty of a crime, and that's why I'm imposing a sanction, for instance, a fine. So then the prosecutor is acting as a judge, and then the prosecutor will say, well, you're guilty, and I impose you a certain sanction. Of course, the accused may appeal to that, and then the case will be brought to court. But a penal order is a legal instrument to impose a sanction without involvement of a judge. So there are a lot of options for the prosecutor to deal with the case outside the courtroom. Okay, let's move on to restorative justice. As I've already told you before, the legal basis is in Article 51H. And, well, that's a broad article, because it states that the police and the prosecutor must inform the victim and the accused or the convicted of the possibilities on restorative justice. So there's not an obligation in each criminal case to try restorative justice, but there is an obligation for the police and prosecutor to inform the accused and the victim on the possibilities of restorative justice. And then it's up to the victim and the accused to use this possibility or not. And in most criminal cases, restorative justice won't be an option, because or the accused is denying, or the victim does not want to be involved in mediation in restorative justice. So in most criminal cases, well, in the Netherlands, we see that the accused and the victim are not willing to engage in restorative justice. In most cases, the victim wants the accused to be prosecuted, or the accused is denying his responsibility. And when he is denying his responsibility for the crime, then restorative justice won't work out. So the case must be suited for restorative justice, and otherwise restorative justice will not be successful. But when it is successful, then there will be an agreement between the accused and the victim, and this agreement between the accused and the victim can take various shapes. It can mean that the accused takes his responsibility for the crime and say, well, I admit I've committed a crime and I'm very sorry about that. And the victim is saying, well, it was not a very good idea. All right, I accept your apologies, and that's it. But such an agreement on mediation can also have a financial aspect. It can also involve the compensation for damages. So this agreement, the content of the agreement depends on what the accused and the victim has agreed upon. It can only be on responsibility, but it can also be on the financial aspects of the crime. But it is an agreement. In all cases, it is an agreement between the victim and the accused. And the question is this agreement relevant for criminal proceedings? Well, the answer is yes. Of course, it's relevant. But how relevant it is depends on the prosecutor, or maybe later on to the trial judge. A successful mediation, successful restorative justice, of course, can be relevant for the prosecutor when he must take his prosecutorial decision. So when the process of restorative justice is taking place in the very beginning, of the criminal proceedings, when there's not yet a prosecutorial decision, then the prosecutor can take the agreement into account during or while taking his prosecutorial decision. And then he can choose for instance, a conditional dismissal. The conditional dismissal, which we've talked about a few minutes ago, he can say, well, I'm willing to drop the case, but only if there will be a successful process of restorative justice. And when you, victim and accused, enter an agreement, well, maybe then going to trial is not very useful anymore. And maybe I'm willing to dismiss the case, but only, of course, only when the accused will meet the obligations which he agreed upon with the victim. So then the outcome of the process of restorative justice may be relevant for the prosecutorial decision of the prosecutor. But that is only an option in, well, minor cases. When the case is more serious, well, then it's good news that there's a successful restorative justice process, but still society asks for a trial and asks for prosecuting the accused. So the prosecutor may also go to trial with the case, And during the trial phase, well, the judge can also promote the possibilities of restorative justice. But then the trial has already started, so then the judge must take a decision on guilt. So then the trial judge will decide on guilt, and in most cases he will convict the accused. But if there has been a successful process of restorative justice, he may take into account the agreement in his sentencing decision. Then he can say, well, I find the accused guilty and I will impose a certain sanction, but in my sentencing decision, I will take into account the agreement. So that can that may mean that he will give the accused a less severe sanction, or maybe not a sanction at all. Maybe he will say, well, the conditions of the agreement between the accused and the victim, that is a sanction enough, and I will leave it to that. So then he will not impose a sanction to the accused himself, but then the sanction will only be, you have to meet the conditions of the agreement. But the difference with the prosecution phase is that there is a decision on guilt, and then the judge has convicted the accused, but in his sentencing decision he may take into account the agreement. So in various phases of criminal proceedings, the outcome of a process of restorative justice may be relevant for decisions which the authorities have to make. So there are legal instruments for restorative justice in place in Dutch criminal justice, especially the basis of Article 51H. And especially the last 20 years, there's a persistent advocacy on restorative justice, because restorative justice, of course, has certain advantages. It can be a good alternative for criminal proceedings, and it can be in the interest of the accused. It can also be in the interest of the victim. So there, well, restorative justice is considered as a good idea, also in criminal cases, not only in civil cases, but also in criminal cases. But nevertheless, we see in the Netherlands, it is used in all courts in the Netherlands. There are options for restorative justice, and we have all kind of mediators in place in the Netherlands, but it's still used in a minority of cases. It's only, well, maybe a few percent of the criminal cases restorative justice is used. And the main explanation is that, well, most criminal cases are not suited for restorative justice yet, or not, are considered to be not suited for restorative justice, because we think there still is a need to prosecute someone, there still is a need to punish someone. Well, and if the accused knows that he will be prosecuted and convicted anyway, well, why would he cooperate with restorative justice? So, and on the other side, also victims, some victims really willing to cooperate with restorative justice, but most victims say, well, no, not for me. They think that this is the case for the police and for the prosecutor and the courts. We're not willing to cooperate with restorative justice. So it's not really flourishing in legal practice. We're using it in the Netherlands and we're trying it, but it's not as widely used as it maybe could be. And that leads me to the conclusion of today. And after that, we will move on to your questions. We can conclude that in the Netherlands, the legal position of the victim has significantly been strengthened. The victim didn't have a very strong or significant position in the Dutch Code of Criminal Procedure of 1926, and he wasn't considered that important during the 20th century. We only needed the victim as a source of information, but we didn't consider the victim as a carrier of legal rights himself. Well, that has significantly been changed, as I've showed you today. It's even so that now doing justice to the interests of the victim is considered to be one of the main goals of criminal proceedings. We think that the goal of criminal proceedings, of course, is truth finding and to punish the accused. And of course, another goal is give legal protection to the accused. But a third main goal of criminal proceedings now is doing justice to the interests of the victim. And the government is really promoting victim rights during last decades. And one of the consequences is that there's also a growing attention for restorative justice. There are a lot of there's a lot of scientific research on restorative justice. There's a lot of advocacy on restorative justice. There are a lot of pilots for restorative justice. So we've tried a lot, and we have also invested significantly in the possibilities of restorative justice. But still, the practice is difficult. It is used. There are possibilities, and sometimes they are successful, but it's not that most of the cases in the Netherlands are dealt with by means of restorative justice. Most cases are dealt with with a normal criminal proceeding or one of the extrajudicial options of the public prosecutor. And restorative justice can be used, and there are possibilities to click it in the normal criminal proceedings. It can be relevant for the prosecution decision. It can be relevant for the sentencing decision of the judge, but still we see that restorative justice is not very widely used yet. But maybe that will change in the upcoming years. But I'm not very positive on that. So I'm curious how restorative justice is used in Indonesia. So that's what it is for today from my side. But of course, I will be happy to answer your questions. Thank you for your attention.
Thank you, Prof. Very interesting to discuss what relation positioning of victim, especially victim procedural right in criminal procedure and rational power of prosecutor and restorative justice. Jadi dalam diskusi ataupun materi yang disampaikan oleh Prof. Yan ini mengkaitkan antara hak dari tersangka dengan kekuasaan diskresional dari jaksa ya, penuntut umum, dan dikaitkan dengan restoratif justice. Okay, all participation now come to question and answer session. Maybe there are questions from the participant. Please use the raise hand in the Zoom and identify yourself, or you can chat in box. Please. Okay, from is okay, langsung saja silakan. Vina ya.
Yeah.
Okay, Vina.
Okay, first of all, thank you for the opportunity, Professor John. I'm sorry if I mispronounce it. So, you've mentioned about the thing that several things that a prosecutor can take after they're done with the investigation, right? Such as like a conditional dismissal trial or conditional dismissal. So I'm just wondering about the unconditional dismissal that you mentioned. So you said that a prosecutor can dismiss a case without the person who committed a crime then paying, like getting any sanctions, such as paying the fine or things like that. So I'm just wondering that, do you really think that it's an effective way to prevent the person who commit the crime to do any more crime the next time, because they just need to promise themselves to behave next time, they're not going to do the same thing? So for the follow-up question, I'm also wondering about what kind of crimes that you are referring as a minor crimes in Netherlands, because you think that, because you said that for a minor crimes that you can just dismiss the case without paying the fine. So yeah, thank you.
Okay.
Thank you. Excellent question. Well, the answer is no. Of course, it's not a very effective way of react to a crime. So an unconditional dismissal is only used when, in specific circumstances. For instance, a minor who has committed a crime for the very first time, and you can a warning is sufficient. Well, then you can say, well, I'm going to dismiss this case, but this is the only time I will do this. But then it has to be a very minor crime, and for instance, committed by a juvenile or an elderly, committed by a very old lady who's stealing something, who's shoplifting, and who's taking something from the store without paying. Well, are you going to prosecute her? Well, you might, but you can also say, well, we're going to dismiss this case, but only this time. So an unconditional dismissal is only for the exceptions in really specific circumstances, but in most cases, of course, you will give a certain reaction, a certain sanction. So a conditional dismissal can be a suitable option, a transaction, a penal order, or going to trial, but an unconditional dismissal, well, only in specific circumstances and only in exceptional circumstances, I would say, because I totally agree with you. It's not a very effective way of dealing with crime. So that will be my answer. Is that an answer to your question?
I'm still wondering, like, what certain question are you mentioning?
No, I mean, is it an answer to your question? Was it understandable for you?
Oh yeah.
Yeah, okay.
Yeah, thank you very much.
Okay, any other question? maybe from experience in Netherlands of can restorative justice be used in serious crime?
Can you repeat it again?
Can restorative justice be used in serious crime?
Yeah. Well, it can be used in all crimes, actually. It is always an option, but you see that it's mostly used, of course, in well, crimes which are not very serious, and especially when it is committed in when the victim and the accused already have a certain relation with each other. For instance, in family relations or in neighborhood relations, then it can be very useful to use restorative justice, because then going to trial and just convict someone, well, that is a reaction to the crime, but then you didn't solve the underlying conflict between certain parties. So if there's an underlying conflict between the victim and the accused because they live next to each other or because they're relatives, then it can be very useful to try restorative justice. But it can be used in any crime, but of course mostly it's more successful in less severe crimes. So, is that an answer?
Any other question?
Can I ask you if the victim impact statement, which I talked about, so the victim informing the judge on the consequences of the crime, is that a possibility in Indonesian criminal procedure?
Maybe the kind of crime we can resolve with restorative justice experience in Netherlands. What kind of case?
Can you repeat it again?
What kind of cases in criminal case we can solve with restorative justice experience in Netherlands?
What types of crimes?
What type of crime?
Yeah, violent crimes, and also well, it's mostly used in crimes with violence, but also in shoplifting or in let's see, sometimes also in when someone threatens another. So that kind of crimes, I would say. Yeah.
Okay.
Any other questions?
Any other from the audience?
Bapak mau nanya lagi.
Okay, monggo Vina.
Sir, what if a foreigner shoplift in Netherlands? Do you apply different rules for them, or do you just deport them to their country?
In case of foreigners, yeah. Well, not really. I think they're treated equally with people who live in the Netherlands. It may differ for the pretrial detention, as we discussed last week, because foreigners will be placed in pre-trial detention easier and earlier than people who live in the Netherlands because of the risk of absconding. But when it comes to the sanction, I don't think there will be a lot of difference, except that community sanctions are it's a bit more difficult to execute a community sanction when it concerns a foreigner, but it's still possible. So I don't think there will be a lot of differences. And the deportation, well, it depends on the seriousness of the crime, but it's not that a foreigner who commits a crime in the Netherlands will be extradited immediately. That depends on the seriousness of the crime, and not for shoplifting, I think. Yeah.
Thank you.
Okay. Prof, can lawyers participate in mediation in restorative justice? Participate of lawyer in restorative justice, in mediation. In Netherlands experience,
Yeah.
Lawyer participate to.
Oh, the lawyer.
The lawyer.
I don't think so. No, the mediation is actually well, he can be involved when it concerns financial aspects, but mediation is really on restoring the relation between the victim and the accused, and it's that is the goal of restorative justice, and the victim and the accused have to do that themselves, of course, with the help of a mediator. But a lawyer, maybe he's not involved in. Mostly, he's not involved in restorative justice. Actually, only for the financial aspects, but not for the restoration, to restore the relation between accused and the victim. So mostly not.
Thank you, Prof. Any other question or enough? Enough, maybe other. Okay, maybe enough, Prof.
Well, thank you very much.
Thank you very much, Prof. Participant, we finally come to end session. I'd like to thank Prof. Yan for interesting topic today. Finally, give applause for Prof. Yan and for you all. Thank you.
Thank you.
Thank you, Prof.
Thank you for the for your attentions and your well, it was an honor to deliver these lectures for you. I hope I've given you some insight in Dutch criminal proceedings, but well, there are a lot of similarities, but it's also there are also a lot of differences. So I can imagine that sometimes it can be hard for you to understand Dutch criminal procedure, but I hope to have given you some insight. So thank you very much.
Thank you very much, Prof.
Okay.
Terima kasih
teman-teman. Another
teman-teman.
time.
See you, Prof.
Okay.
Teman-teman, untuk diskusi kali ini kita akhiri. Terima kasih. Selamat sore. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Bye-bye. See you.
J, Bu. Thank you.